Welcome to another episode. I know you're hearing a lot of changes here in the real estate area, basically, where it comes. There's all kinds of stuff. There's lawsuits and stuff like that. We're here to interpret basically what it means to you, the seller. So basically, one of the major changes that's important to you, the seller, and the buyer is the property disclosure form. So basically, I'm here with my special guest, Peter Goodman. Peter, how are you?
Good. How are you today?
I am good. I'm trying to get as much information out there to the people so basically they're not bogged down with what they're hearing in the news and getting misinformation. So that's one of the points of why we're putting this video together. Without further ado, let's just get into it. What is it that changed basically with the property disclosure?
All right. So, yeah, you're right. This is something that people hear about, and then everyone has questions about it. Always with a new law, that's the way it is. Of course, like with new things, everybody hears something different. Maybe they hear part of it and they get worried. But it isn't. It really is just an add-on for a law that's existed for many years already. What I want to talk about today is the who, why, what, when, and where. Let's make it as easy as possible so you can digest it and you can understand what your obligation is if you're selling property and what you should do if you're buying. So let's talk about the who. So this relates to only residential real estate. So if you're selling a house, 1 to 4 family, you need to know this law. Okay, it's called the It's called the Property Condition Disclosure Act, and there's something called the Property Condition Disclosure Statement. There are exclusions. So if you're selling vacant land, if it's a condominium or a co-op, if it's an estate sale, you're selling a property with letters testamentary, letters of administration because someone passed away, the property is owned in a trust. There are other exclusions too, but those are the basics that everybody should know. Let's talk about the why. For years and years and years, real estate has been what's called caveat emptor, let the buyer beware. Everyone, when you start selling a house or start thinking about selling or buying in New York, you hear about as is, the house is going to be delivered in as is condition. So that's always been the law of the land. The seller always had no duty to make any statements about the condition of the property. That's except for fraud. So they could just say the property is as is, you're taking the property in the condition it's in now, but you couldn't materially hide anything. You couldn't like build a wall to hide a leak or something like that. But as long as you weren't doing that, it was as is and there was no issue. So over the years, we wanted transparency. We wanted to maybe even out the scales a little bit. So the Property Condition Disclosure Act, it's part of the real property law, seeks some more transparency in what the law is saying and what's provided. There was always these, at least for the last 15, 20 years, has been this property condition statement that sellers are supposed to fill out. It had 48 questions about the condition of the house. You could answer yes, no, unknown, or not applicable. But there was, you remember the old Monopoly game, the get out of jail free card? There was a get out of jail free card, which was $500 you pay, and now there's no liability to the seller. Doesn't matter, just you don't fill the form out at all, and you just give a $500 credit at the closing to the buyer. Well, that's what was removed. The state no longer wants people to opt out of any potential requirements for liability for not disclosing something by just paying $500. So let's talk about the what. It's actually now 56 questions. So this is actually your questions that you have to answer. It's about general questions such as how old is the house, how long have you lived there, some basics. And then the other questions that are more specific, what certificates of occupancy do you have, environmental questions about flood zone, in a flood zone, do you need flood insurance, have you had experienced the flood? Those are the types of questions that we have now. There are 56 questions, 7 new questions were added to the law. So understand, though, sellers have actually no obligation to make an additional inspection. You don't have to start doing an inspection if you're a seller. All you have to do is answer the questions to your actual knowledge. You just have to put down your actual knowledge. You have no obligation to make a special inspection. If you fail as a seller and you willfully fail to provide the statement or correct answers, then you're liable for actual damages or any equitable statutory damages. You potentially can get sued. I mean, that's what you need to understand. Next, let's talk about, that was the what. Now let's talk about the when and where. First of all, when do you need to disclose the form? Well, you need to fill out the form as soon as you start listing your property. And you're going to get the form from your real estate agent. If you have a listing agent, you get it from them. If you're a buyer, you're going to get it when you first meet your agent. Or if you don't have your own agent and you're going to the listing agent or selling agent, you'll get it when you first start working with them. That's when you're supposed to get it. But understand, real estate agents have no duty to help you fill out the form, and they shouldn't be. They're actually recommended not to fill out the form. This is for attorneys and their clients. It's not for realtors. Realtors have an obligation to inform you that you have the obligation as the seller or as the buyer that it's going to be coming, but they don't have to help answer the questions, and they shouldn't. So don't be offended if they don't help answer the questions, because they're advised not to, and they're not attorneys, so you should be speaking to your attorney about that.
Can I simplify that and just do it in human speak? When I'm listing a property, I will bring it up. I'll show it what it is, and I will give it to you, the seller, and I'm going to tell you specifically, talk to your attorney about this, fill this out to your best of your knowledge, and speak to your attorney. Plain and simple. And for the buyers, basically, if I'm listing a home, most likely what we're going to end up doing is putting this form basically in our MLS. It'll be attached. So if you have a buyer's agent on your side, they will see that, and then they'll have that copy, give it to you and your attorney so you can review it. And the same token, you're still doing your home inspection. Nothing's changed, but everything is going to be on that.
Yep. So let's continue with the when and where. So when you're getting it from your real estate agent, the where, it has to be included with the contract of sale. So what happens is you're not fully obligated to sell and you're not fully obligated to buy until the contract has been signed by both buyer and seller and there is a down payment. When that contract gets submitted, it has to have a copy of the property condition disclosure. And here's something also that really people should know is that the law has a revision clause in it that says that if something changes, so you fill out the form, you list the property, and a month later you have a buyer, and then you go into contract, and 3 weeks after you're in contract, you experience a flood. That is something that has to be disclosed now. So you have to now update the disclosure. Once you close and you sell the property, you don't have any more obligation. But up until the day of closing, if something changes, you are expected to submit a new updated form. Okay, so that's the when and where. Now let's just talk about best practices for a second. Number one, I always advise this if anyone has seen me do any of these presentations or videos before, but I always advise everyone, get your attorney early. It's like getting your team in place we talk about. Get your realtor, have your mortgage people, have your home inspector. Get your attorney early, because if you have questions about how to fill it out, you have questions about the process, you need to know early so you're not scrambling at the last minute. Understand that you are
Can I interject 1 second? This is where it's really crucial that whoever you hire as an attorney has to be someone who does real estate law on a regular basis. It can't be someone who does something else, and they might dabble in real estate, but it has to be somebody who does this full time. This is their bread and butter, because most like, no shade to anybody who does other things, but someone who does this practices, someone like Peter who practices on a regular basis is going to be well versed on this and knows exactly what this is. So when it does come up, they can address it to you. If someone who doesn't do this, they practice other law, basically, they might be focused on other things at the time. They might not be aware of this, and they might not be able to give you the right advice for this. This is really crucial that who you hire is very important. And like you said, we're building a team. If I'm sitting with you as my client, whether you're a buyer or seller, the first thing I talk to you about before we do anything is we have to identify who your team members are. So that's your real estate attorney, your loan officer, your realtor, your home inspector, and whoever else basically might be involved in as well. Sorry, go ahead.
No, that's perfect. But just like you said, I mean, that's why we always say real estate attorneys, don't use your brother-in-law who's a corporate attorney, just because when laws change, if you have a perfect transaction where nothing goes wrong and you don't need to worry about anything, fine, you can use your corporate attorney. But how are you going to know that's going to happen? It's when the problems occur, when issues like this come up, that's when you'll realize that there was a mistake if you didn't have a real estate attorney. So let's get back to best practices. Property owners, you have to fill out the form yourself. The law specifically says fill it out themselves. You can certainly ask us as attorneys for advice on it, but you have to complete the form yourself and to your best of your actual knowledge. Doesn't have to be, again, you don't have to make assumptions. You don't have to start doing research or inspections. And one other thing that we do, I am telling people, is that they should check. A lot of people don't know if they're in a flood zone. They may have, if you need flood insurance, you're in a flood zone, right? If it was required. But other than that, that's one thing that, while, again, you don't have to do any inspection, so you can say unknown. I think there may be people in the future saying, well, How did you not know they were in a flood zone? So you can check. FEMA has maps. It's easy to find. I think it's a good idea to just check the flood map to see if you're in a flood zone. I mean, that's easy. And another thing that you should know as sellers, this is super important. Yes, we talked about as is being changed a little bit, the caveat emptor, let the buyer beware, changing a little bit, but it's not really. You can still, if you have a buyer that does a home inspection or sees something that's wrong with the property, or knows something's wrong with the property, or has a hunch something's wrong with the property, you can still freely negotiate a contract that says we're giving you the property, but we don't have a certificate of occupancy for the deck. We're giving you the property, but we're disclosing that the stove is not working. Things like that, you can still put them in the contract. You're still free to negotiate whatever you want. There's freedom of contract. So you don't have to worry that, hey, what am I going to do now? This is broken. Do I have to fix it? Well, if the buyer is willing to take it as is, they can still do that. It just has to be disclosed in the property disclosure form. Also, if you're a buyer, buyers need to read the questionnaire, because it has some important questions, and you should be looking at the answers and then possibly forming making a decision as to whether you want to address it with the seller further in the contract of sale, perhaps. It's not a warranty. Having these disclosures requires that, hey, look, if they make a mistake, the seller, well, if it was an honest mistake, there's no liability. If they willfully made a mistake and they lied about something on the form, they can be sued. Lawsuits are expensive. If you have something minor that maybe costs $1,000 that in liability, well, are you going to sue the seller over that? Maybe. It's probably not worth it. Even in small claims court, it might not be worth it. So the bottom line is, if you do your own regular inspections, we talk about regular home inspection. If there's a cesspool or septic, you should do those inspections. There should be termite inspections, right, for wood destroying insects, and others. If there's a pool, if there's sprinklers, things like that, you might want to have separate inspectors ready to go. But the bottom line is, there is still let the buyer beware. It's still do your own inspections. Doesn't change anything about what we would advise a buyer to do when they're preparing to buy.
So we delved into a lot of stuff. So I just want to recap basically what were the exclusions basically for this form.
Okay, so the basic exclusions are if the property's in a trust, if the property's in an estate, if it's a condominium, if it's co-op, if it's vacant land. Those are the basics. I mean, there are some others, properties pursuant to a bankruptcy sale, things like that we don't need to get into, but the basics are what I just said.
All right. And then the other thing is basically this takes effect by the time of this recording. We're doing this in March, early March. This is March 16th. And I believe this takes an effect basically after March 20th. Am I correct with that?
4 days away. We're right there.
So pretty much the seller fills out the form on their own to the best of their knowledge and put everything that they know of basically onto the form. And basically this is prior to signing a listing form and also before the contract. Is it before or after the contract?
Okay, so, well, first, it's when you do the listing. That's when you should be giving it to the seller or informing them about it. But it has to be included when the contracts are signed. So it's an attachment to the fully signed contract.
Okay. And then what are the other stuff that we discussed that you want to shed some more light on?
Are you talking about in terms of the property condition disclosure or something else?
Just everything, basically, if you could sum it up.
Okay. Well, I'll sum up the PCDS. There are a lot of other things going on in the world right now, but I think I don't want to confuse anyone or make anyone nervous. So the bottom line is, make sure you get the form, make sure you read the form, make sure you complete the form to the best of your actual knowledge. Make sure it's included with the contract. If anything changes between contract and closing, make sure you update the form. And buyers, make sure you still do your inspections to make sure you know what you're buying.
All right, Peter, thank you so much for your time on this. There are other things going on right now that we'll be doing videos about in the future as well. Peter, how can they reach you if they have any questions regarding this form or anything else regarding real estate law?
So the easiest way to reach me is to email us at RE as in real estate at bfslawfirm.com. That's B as in boy, F as in Frank, S as in Sam, lawfirm.com. Or you can call my office. You can reach the New York City or Long Island offices through 516-747-1136. I look forward to seeing you guys out in the world.
All right, this is Evantz Saint-Gerard with Team N.W.E. I want to say thank you for watching. If you have any questions regarding this or any other topics regarding real estate, residential real estate, feel free to reach out to us. You can reach us on our website, which is mynyhomesales.com. You can also reach me on my cell phone, 917-975-5985, and our office line, which is 718-475-2760. I'm Evantz Saint-Gerard. Thank you for watching. Stay good. Keep it moving. Stay positive. And we'll talk to you soon.